Gavin, our government law and justice expert, is here to talk us through some of these current issues. Gavin is also the workshop director for several of our law and justice related programs, and we'll mention one or two of those at the end of the session. When Gavin's finished his presentation, he'll be very happy to take questions, and I think throughout a part of the presentation we may put some questions to you in one or two polls, but I'll let Amanda, my colleague Amanda, explain a little bit more about that and about the webinar software. So let's hope all the technology works and we can run it smoothly. So thank you very much again. I'll look forward to rejoining you at the end of the Gavin's presentation. Thank you.
Thank you, Claire. So good morning or good afternoon, everyone. Welcome to this Justice webinar with Professor Gavin Drury. I'm just going to be very quick and run through a few admin points. On the left-hand side of the screen, you'll see there are several boxes. You have a questions box that Claire was just mentioning. If you have any questions throughout, please do put them in the question box, and we will be reading and answering these questions at the end of the webinar. We will also be launching polls throughout the webinar as well, so we do ask that you participate and answer those. There is also a chat box, so please feel free to talk amongst yourselves within this chat box. If you have any technical queries, please do ask myself or my colleagues. And the handouts box, you'll notice that it's empty at the moment, but once the session ends, you will be given links to our website, reading material, a copy of the slides, and also a recording of the webinar. As I said, if there's any questions or anything like that, please do use the chat box if it is to do with any technical questions, or if you just want to debate amongst yourselves. And if you do have any questions for Professor Drury, please do use the question box. Gavin, what I will do now is hand over to you.
Right, here I am.
Thank you, Gavin.
I hope everyone can see me. Regrettably, in present circumstances, I can't see you. So it's a bit of a one-way street in that respect. However, and first of all, thanks very much to Claire for her kind introduction and to Amanda for her technical advice, which we may have to call upon later because we're all getting used to this new mode of presentation. One thing that both of them said is please make use of the chat box and the questions facility. It's very easy with this kind of format for it to become a kind of sermon from the pulpit by the professor. I don't want it to, inevitably that will be partly the case, but I don't want that to become the dominant sort of message that comes over. I really do want to get some feedback from you, and I will be very pleased to answer any of your questions. And do talk among yourselves through the medium of the chat box. So let me get to the substance of my presentation. And here is a slide showing what I intend to do. First of all, the theme of my presentation is the rule of law, and we need to say something about what that actually means in theory and in practice. Secondly, we need to justify why it needs to be taken seriously. There's an inclination, particularly when professors are talking, for people to think, oh, well, there's somebody going on about one of their hobby horses. Well, yes, the rule of law is something that's always interested me, but it isn't just a theoretical abstraction. It's something that is a very real concern to everyone in the world today, particularly a world in crisis. A world in crisis, of course, because of the horrible COVID pandemic, but in many parts of the world, there are other crises as well. And my own country, the United Kingdom, is by no means, I was going to use the word immune, and I will use it anyway, but it sounds as though I'm making an unhealthy pun. But that wasn't my intention. We live in a difficult world, and the rule of law is very important in that world, and faces many challenges, as we will see. So I'm going to say very briefly a few words about the origins of the concept of the rule of law, then a bit about how it has developed, how it continues to develop, both in domestic governance and in the international arena. And lastly, some threats and challenges to the rule of law, ones that arise from COVID-19 and from elsewhere. And the elsewhere in the UK, as we will see, includes our continuing problems and challenges arising out of the Brexit decision, some of which are unfolding even as I am speaking. And just a few reflections on what can be done to combat those threats. And I hope, particularly in the latter context, you will come back to me with some comments and observations and suggestions arising from your own national and local experience. Now, what do we mean by the rule of law? Well, we can approach this in pages of script and text, and there'll be a little bit of that later on, but only a little bit. I thought it might be helpful just to sum up three main ingredients of what is, as I've used the metaphor, a very difficult recipe. First of all, the rule of law has to do with the legal and constitutional accountability of government and public office holders by way of judicial review in the courts. I use the term judicial review, which means different things, of course, in different jurisdictions, but I think you will know the kind of thing that I mean. Secondly, judicial independence. A judiciary that's not only independent, but a judiciary that is competent, can do the job effectively and efficiently, and a judiciary which itself is honest and has clean hands in doing its, in discharging its functions. And lastly, and this sometimes gets to the back of the queue when we're talking about the rule of law, but it's extremely important. The rule of law means access to the courts and a guarantee of a fair trial by due process of law for all citizens, whether they be rich and can afford expensive legal representation, or whether they are poor and can't even begin to pay the kinds of fees that courts and legal representatives often demand. Now, as I said at the beginning of this slide, I'm going to get on later to some elaborations of the definition of the rule of law. But before I do that, I'd like to just make a few preliminary observations. And the first one is that in this context, as in so many when we're talking internationally and cross-nationally, one size doesn't fit all. The rule of law can and does mean different things in different countries and cultures. But there has been a long-standing and continuing effort in the international community, particularly in the UN and its satellite organizations, to achieve some kind of broad consensual working definition of the rule of law and to encourage respect for it. And I'll come back to that later. Secondly, the rule of law is something positive, something I certainly think is positive, and I hope you do too. And governments tend to say they think it's positive and sort of mean it. But it isn't always seen by those in power as a supportive adjunct to good governance. It is sometimes resented by politicians and office holders as standing in the way of what they want to get on with their own plans and ambitions. So the rule of law is something about which governments have slightly mixed feelings. Third bullet point is that the rule of law, yes, it underpins democracy and human rights, but it's something that empowers the judges. And judges in most countries and most jurisdictions are not elected office holders. And so elected office holders in parliament and in government who have a mandate from the people to promote policy and legislation sometimes are suspicious of non-elected judges thwarting the actions of elected governments. Okay, the rule of law is confined to illegality and constitutional malpractice, but even so, questions are sometimes raised about making judges a little bit too powerful. And we're, even as I speak, that we have the situation in the United States in the run-up to the presidential election following the death of Justice Ruth Ginsburg and the debate about how the vacancy in the Supreme Court is going to be filled. And there's a lot of the kind of debate that I've been talking about judges and the politicization of the judicial process and judges actually taking decisions which in other contexts politicians want to take is very pertinent to some of the debates that are going on in that and other contexts. Something I touched on earlier, the judges themselves must have clean hands. The credibility of the rule of law suffers if the judges themselves are perceived as not having clean hands, as not being seen fairly or unfairly as being incorruptible and non-corrupt. And lastly, and this is something that's been really exercising us in the UK over the last week or two, for reasons that I'll come back to later. The rule of law includes not just domestic law, but also respect for international law and treaty obligations. It's the basis for maintaining trust, not only between citizens and government, but also between nations, particularly when it comes to trading relationships. And the context in which this has been particularly controversial in the UK over the last few days is to do with Brexit, the withdrawal agreement that the United Kingdom signed up to at the end of last year, and some ongoing attempts by the current government to provide for the possibility of reneging upon treaty obligations. And that has caused a great deal of anxiety and a great deal of controversy. And that controversy is not resolved even now. One thing we must remember when talking about the rule of law is that it has economic and democratic significance. We think of the rule of law as perhaps being the province of constitutional lawyers, but in fact, it goes much deeper and wider than that. There has to be confidence in the effectiveness, fairness, and integrity of a legal system, both for citizens and those doing business. The rule of law underpins democracy and respect for human rights. The rule of law in a globalized world has to do with good governance and, as I said just now, trust between nations. Confidence is in law, the necessary confidence that we need in a joined up world, bestowed by concepts like the rule of law, comes under threat if there are defects in the legal system or shortcomings in the integrity of the judiciary. And one consequence of the loss of trust in domestic law, and I suppose in international law as well, is that if you don't trust the legal system, you begin to think of ways of taking the law into your own hands. And that is, once you start doing that, then you're entering a scenario in which the social contract begins to look fragile and vulnerable, and governance itself falls under severe threat. Now, I said I'd speak briefly about the origins of the concept of the rule of law, and here is a slide that contains some highlights going back several hundred years. And this isn't a history presentation, so I'm not going to go into any detail. We start with Magna Carta and we go through Thomas Paine in the 18th century, Thomas Adams in the United States, also in the 18th century, A.V. Dicey, who some of you have studied law will have come across probably as a great UK constitutional lawyer, whose great work was done at the end of the 19th and beginning of the 20th century. And into the modern era, and here I'm going to just pause for a moment, we have the well-known figure of Margaret Thatcher, who was an important and controversial prime minister back in the 1980s. And Margaret Thatcher, to some people's surprise, because she's often depicted as an authoritarian kind of person who was impatient to get round legal principles. Some truth in that, but not entirely fair, because she was a fierce advocate of the rule of law. And on the slide, you will see a quotation in which she is very fierce about this. You cannot have freedom without a rule of law. And if you don't have it, what you tend to get is corruption. And that is death to freedom, it's death to truth, it's death to honor, it's death to democracy. And Margaret Thatcher said that a few years after she ceased to be Prime Minister. And it represented a view that she espoused really throughout her whole political life. And on the next slide, I've quoted an academic, a right-wing philosopher, much favoured by Margaret Thatcher, who called Roger Scruton, who sadly died a few months ago, in which he produced really rather a nice, crisp definition of the rule of law, which Margaret Thatcher thought rather appropriate. Scruton spoke about the rule of law as a form of government in which no power can be exercised except according to procedures, principles, and constraints contained in the law, and in which any citizen can find redress against any other, however powerfully placed, and against the officers of the state itself for any act which involves a breach of the law. Well, now, back to Margaret Thatcher. I said just now that she was a fierce champion of the rule of law. The slight downside of her position was that it was based very much on a rather nationalistic view that the rule of law was something that had been invented by the United Kingdom, and the United Kingdom had a duty to kind of teach other nations and non-believers about its importance. And that, of course, isn't quite so uncontroversial as advocating the rule of law as a healthy principle. And I'm certainly not, and particularly in the light of recent developments, which I'll come back to, myself promoting the United Kingdom as an untarnished exemplar of everything that's wonderful about the rule of law. There's been some backsliding and some controversiality in recent events, which cause me certainly, and others I think too, some concern. And I'll be coming back to some of those concerns with particular reference to the COVID crisis, which is, it's very much on our minds at the moment, and is epitomized by the fact that I'm talking to you online rather than face to face. Legal implications, which have implications for the rule of law, that I'll say something about later on, and the specific issue of Brexit in the United Kingdom, both of which I will come back to later on. But I want for the moment to move away from the debates in the United Kingdom towards the international stage, and some of the debates and utterances that have been evident in the international community over the years, and still are, about the rule of law. And I could, at this point, produce a long catalogue of international organizations, all of which, in one way or another, have been promoting the rule of law alongside human rights and civil liberties concerns. And that would take a very great deal of time. So I've just picked out a couple of examples with websites that I hope you will follow up if you're interested in doing so. And the first that I've chosen is the International Bar Association, which has a rule of law forum. The International Bar Association has a representative and educational function internationally, though it's based in the UK. It's by no means a UK-orientated organization exclusively. And the website there is to their rule of law forum, which includes definitions of the rule of law and some exhortations on those who visit the website and who are members of the IBA to promote those principles and to follow them. There is the World Justice Project. And one of the interesting things about the World Justice Project is that it produces an annual rule of law index. And you can see its web address there. Now, I had a terrible temptation at this point to sort of start going into league tables about the relative standing of different countries in this league table. There are all sorts of problems with doing this. One is that it would take a long time to do that. I would inevitably be including some countries that are represented and present here in this webinar, and other countries that are not. And the methodology of these things, although interesting, is often a little bit suspect. But you can, by looking at the website, detect some broad trends. For example, the Rule of Law Index over the years have noticed some backsliding on the part of countries in their commitment to anti-corruption programs, which are necessary for the healthy state of the rule of law. So do by all means look at that if you're curious about doing so, and have a furtive look at where your own countries actually sit in the league table, but don't actually necessarily take this as rocket science, because in my opinion, it isn't. Apart from a lot of NGOs that have been promoting this around the world, representative organizations of one sort or another, the lead player almost inevitably has been the United Nations. And if you turn to the United Nations websites, you'll find some definitional statements about the rule of law and what it actually means. There's a slide there in front of you, which it would take me 2 minutes to read, but I'm not going to read it because you have the text there. And it doesn't really contradict anything that I've already said. It has to do with fair trials, equal adjudication, adherence to the principles of the supremacy of law, equality before the law, and judicial independence, those kinds of things. So I just commend that slide to you to read at your leisure if you have any. And moving on from the United Nations, just to note that among the 17 Sustainable Development Goals of the UN, which were adopted by the UN at the beginning of 2016, setting a program for elimination of poverty and the improvement of the well-being of mankind, with a target date of 2030 as the completion time. Among those Sustainable Development Goals is number 16, which you see flagged up here with a little picture attached, and that is to do with peace, justice, and strong institutions. And the word justice needs to be emphasized here because it's very much a rule of law orientated meaning of justice. And here we have, soon after the COVID crisis really began to stimulate governments to take urgent action, here we have the Secretary General, Mr. Guterres, saying some very strong things about the importance of the rule of law and some of the threats that are posed to it by the temptation that the COVID crisis may put in the way of authoritarian political leaders. Against the background of rising ethno-nationalism, populism, authoritarianism, and a pushback against human rights in some countries, the crisis, that's the COVID crisis, can provide a pretext to adopt repressive measures for purposes unrelated to the pandemic. This is unacceptable. The best response is one that responds proportionately to immediate threats while protecting human rights and the rule of law. And that is, in my opinion, a very nice, crisp and unequivocal statement in support of the rule of law, and contained within it are some warnings, which I'll come back to at the end of my presentation. So let's move on in the second half of my presentation to look at some of the challenges to the rule of law, particularly ones that can arise from the COVID-19 crisis. And as I said at the beginning, and this is really a reiteration of this in slightly elaborated language, I'm going to ask you to keep in mind the three key elements of the rule of law, ingredients, if you like, to use that earlier metaphor. First of all, that government and its officers and those employed by government, including, and this is absolutely crucial, top ministers and even presidents, and for that matter, judges, must be liable to challenges in the courts for illegal or unconstitutional acts. Secondly, judges must be politically neutral, they must be free from corruption, and they must be independent of external pressures, particularly from the government of the day and from political actors. And thirdly, this point about access to justice. Citizens, rich and poor, literate and illiterate, must have reasonable access to the courts, and those charged with criminal offences must be ensured a fair trial. And for that purpose, And this is absolutely crucial. And again, it's something that tends to get pushed to the back of people's minds when they're talking about the rule of law. The judicial system must be properly funded and resourced. If you have a judicial system that doesn't have the resources to do its job properly, then the rule of law is just empty rhetoric. It has to work properly if citizens are to have a fair day in court, both in the civil courts and in the criminal courts. So that's the second half of my presentation. But this is the moment, I was going to say the moment you've all been waiting for, but you probably haven't. This is the moment when I will hand over to Amanda, who is going to steer you through a short poll with 3 questions on it, which I'd like you to address. And we will have a pause, and Amanda will preside over that pause while you reflect on your responses to those polling questions.
Thank you, Gavin. I'm just going to start the polls now. So I'll start with question number 1. So if everyone can participate, that would be absolutely brilliant. We will show the results of each of the polls at the end of the webinar as well. I'll just give you a few moments more before I move on to question 2. Okay, let's move on to question 2. Okay, I'll just give you a few moments more for anyone who still wants to answer. Okay, I'll move on to the last poll question. Just so that people are aware, if you haven't had a chance to participate in the polls, you can do that throughout the webinar. And at the end, we will give out the results. Is everyone finished with question 3? Okay. Gavin, I will hand back to you.
I'm just checking that my microphone is on. Can everyone hear me?
We can hear you loud and clear.
Excellent, good. Okay, well, thank you very much for taking part in that poll. I've had a little sneak look at the results, and they're quite interesting. Inevitably, in a small poll, you're talking about quite small numbers, and it's difficult to draw trends. But one or two points which we'll perhaps come back to at the end, when everybody, including people who perhaps haven't participated yet, have done so. Okay, now I want to spend a little bit of time I said at the beginning that, and I repeated when we encountered Mrs. Thatcher, that the United Kingdom, although it's always been quite proud of itself as being a rule of law country, has been facing some pretty difficult challenges over the last few years, and some of those challenges have surfaced in fairly dramatic ways in the last few weeks and are ongoing. And the two challenges, as I said earlier, are the COVID crisis, which has been at the top of the UK political agenda for the last 6 months, and is still there, way ahead of any other issues. And the other issue, of course, has been Brexit, which has been simmering away since the referendum of June 2016 produced a small majority in favour of leaving the European Union, which in fact we already have, although there is quite a lot of unfinished business, and some of the current controversy relates to that unfinished business. So the UK government has been faced with simultaneously with two huge issues and critical issues. And generalizing from the UK experience, I think there are two important truths about the impact of the COVID-19 crisis. First of all, in our country certainly, and I think in pretty well every country, you can't treat COVID as something that is completely has a context all of its own in isolation from everything else. COVID actually needs to be considered alongside other things that are going on in science, in society, and in government. And you know, the idea of a single cause effect kind of set of results arising from COVID is unrealistic. And secondly, COVID has impacted on several important aspects of the rule of law. But in the UK, and I think in other countries that I know a bit about, and you can confirm or refute this, most of the impact of, or much of the impact of COVID-19 on the rule of law has been to open up cracks that were already there in the system and in the concept of the rule of law prior to the COVID crisis emerging. And the effect in the UK has been really to accelerate the demand for reform and modernization of our legal and constitutional system. So very often a crisis like COVID actually picks up things that were already trending to use a social media term, beforehand. Now I'm going to say a few words about Brexit. And I'm going to focus on 3 episodes. I could spend probably a whole day, if not a whole week, talking about the impact of Brexit. But I'm going to focus on 3 things which actually highlight some of the things that have been challenged in a rule of law context, arising out of the outcome of that Brexit referendum back in 2016. And the first 2 of them are known as the Miller cases. And I'll show you a picture of Miller in a moment. And the first of the Miller cases, which was decided in the High Court, in Divisional Court of the High Court in London, and then confirmed by the UK Supreme Court subsequently, had to do not with the rights and wrongs of the Brexit decision itself and the outcome of the referendum, but with the government's initially declared intention of proceeding to implement Brexit without reference to Parliament. And a lot of people thought that whatever you think about Brexit in terms of its merits, things have to be done properly, and parliamentary sovereignty and the proper role of the legislature needs to be respected, and the government can't just proceed by decree. So challenges were mounted in the courts, led by a very formidable person called Gina Miller. This is the Miller I was talking about. She is a lady who has very strong views and is a very successful businesswoman, and she was concerned not just with the constitutional implications of Brexit and how you implement it, though that's what the case was about, but with its devastating effect upon the economy, upon business. So there she is, standing outside the High Court after the decision in Miller 1, which the government lost. The government lost the case, both in the High Court and in the UK Supreme Court. And I pause there to show you a picture of the UK Supreme Court, which is a comparatively new institution. Formerly, our Final Court of Appeal was bizarrely located in the House of Lords, which is the second chamber of our legislature. We set up a proper Supreme Court in 2009, and we housed it in a former Crown Court building. And any of you who, as I hope will be the case, come and visit us in London and participate in PAI law-related programs will almost certainly have an opportunity to have a guided tour and a talk in the Supreme Court building. So there's a little advertising plug, but a picture of the building in which that final decision was confirmed. And the government lost the case. And although it was really about parliamentary procedure and the parliamentary sovereignty and the need to involve Parliament in the final decision, a lot of people in the Brexit favouring fraternity, Brexiteers as we sometimes call them, were very angry about the decision and thought this was an example of the courts interfering in a deeply political issue. And the press, in particular the tabloid newspaper press, which is pretty heavily slanted towards towards Euroscepticism and favouring a Brexit outcome, were outraged by this and produced all manner of pejorative headlines about the wicked judges, particularly the judges in the High Court, who had come to this wicked decision to say that Parliament ought to have the last word. And there is the slide with some headline examples. But perhaps the most vivid was the front page of the Daily Mail, which had pictures of the 3 delinquent, as they saw it, judges in the High Court who had come to this supposedly outrageous decision. And there they are, enemies of the people, wearing their wigs. And the man in the middle, the judge in the middle, is Lord Justice Sales, now Lord Sales, who's been promoted to the Supreme Court since then. And I made a joke to him about the fact that it was lucky he was wearing his wig in the photographs, because he wouldn't have been safe out on the street. And he laughed and agreed and said that this is one of the good reasons for judges wearing wigs, that they can maintain their anonymity when people are angry with them. But the fact of this headline appearing in the popular press, and I don't want to go on about this forever, but the government actually only in a very lukewarm way defending the judges from these kinds of attacks. The Minister of Justice swears an oath to uphold the rule of law. And the Minister of Justice at that time, a lady called Liz Truss, who is now very much involved in the Brexit negotiations in a different capacity, really spoke about the freedom of the press, and only very weakly spoke in support of the judges against these kinds of attacks. And that's part of what I meant when I said that we're in a bit of trouble with our own claims to upholding the rule of law. There was a second Miller case much more recently, and that was soon after Boris Johnson became Prime Minister, and Parliament was deadlocked over what to do about Brexit, what sort of Brexit we should be negotiating with the European Union. And the Parliament was completely deadlocked, and Boris Johnson couldn't see any way out of it. And so his solution was to prorogue or suspend Parliament altogether in order to let the clock run down towards the Brexit deadline, so there wouldn't be any troublesome debate. And a lot of people were very outraged by this, and Mrs. Miller and another lady in Scotland took cases to their respective courts, and eventually these cases ended up as Miller 2, the second Miller case, the reference for which you can see there if you want to look it up, in which the Supreme Court unanimously held that the government was acting for improper motives, and that its behaviour in setting aside parliamentary sovereignty and suspending Parliament was, to all intents and purposes, unconstitutional. And so they ordered the reconvening of Parliament, and that was done. This was subsequently overtaken by a general election, and Boris Johnson, I said he was Prime Minister then, he wasn't, he was leader, he was Prime Minister, but he wasn't an elected Prime Minister. He won the corresponding, he won the ensuing general election, and of course he is Prime Minister even as I speak. So that was Miller 2. And the third example is something called the Internal Market Bill, which is currently before Parliament. And if you Google up UK parliamentary proceedings or the pages of English newspapers, British newspapers generally, you will find huge ongoing controversy, because in this bill, which on the face of it is a precautionary measure in case we don't manage to strike a deal with the European Union, in order to enable our own internal trading market to survive in the aftermath of Brexit. This actually contains provisions which set aside some aspects of the withdrawal agreement that was negotiated with the European Union at the end of last year and embodied in a treaty signed both by the EU and by the UK government. And even some very strong proponents of Brexit are extremely uncomfortable and angry about any retreat from our treaty obligations. Even if you are very strongly committed to the hardest of hard Brexit, the idea of actually setting aside a treaty obligation or giving yourself the powers to do that is anathema, and that is why this bill is so very controversial. And 5 former prime ministers, all of Mr. Johnson's predecessors, have now spoken out against this aspect of the bill. So it's an ongoing debate, a very interesting one, and one that's very relevant to our concerns in this webinar. Now I want to move on to COVID, and I've just flagged up a couple of little notices that I spotted on the London transport system when I was travelling last week. And on the left, you will see that under transport regulations, delegated legislation that gives power to make bylaws to London's Transport Authority, fines can be imposed on those who don't wear masks on the London tube system. And then there was an announcement on a major London railway station reminding people to keep their distance, the 2 meters distance that medical opinion says are necessary in order to avoid transmitting the virus. I do this just to sort of initiate the discussion about COVID, but actually I just flag up 2 things. One is that fines are now being levied in the UK for violations of COVID regulations. And secondly, on the right-hand slide, the word please. The word please is an exhortation. It's not a legal requirement in itself. And it reflects the fact that until now, the UK government has tended to proceed by persuasion rather more than law. It's now beginning to tighten up its stance, and new restrictions have just been announced, which have a more legalistic flavour. But so far, we have adopted a less law-driven kind of style. Other countries, and I'll come back to this in a minute, have proceeded more legalistically. So there we are. From Brexit to COVID-19, every country has had its own debate about COVID and how best to handle it. And a lot of the steps that have been taken, different though they are in one country as compared with another, have implications, quite big implications, direct and indirect, upon the rule of law. And a lot of the debate, bullet point 2, has boiled down to an argument about whether to invest your efforts into protecting the economy, maybe at the expense of protecting public health, or vice versa, whether you go overboard in the protection of public health aspects, but at the expense of aspects of the economy. And there have been huge variations from one country to another. Some countries have adopted very tough measures backed by the full force of the law, heavy surveillance, harsh penalties for violations, lots of police activity. And others, including the UK, have followed a rather more voluntaristic strategy, relying on common sense and mutual respect. There is a third approach which has been adopted in some parts of the world, and and there are hints of this perhaps in Mr. Trump's America, but even stronger hints of it in some parts of South America, where COVID has been a terrible plague and with huge losses of life and damage to public health, where political leaders have actually tried to deny that the virus is a life-threatening problem. So there have been lots of new rules, and these new rules have raised questions about enforcement, police powers, and penalties. The kinds of things I'm talking about are lockdowns, travel restrictions, quarantine rules, social distancing, limiting how many people can gather together in a single place, the imposition of curfews, requiring the wearing of face masks. All these things underpinned to varying degrees by law and exhortation have huge implications for the rule of law. And they have huge implications for due process of law in the courts and the right to a fair trial. In the United Kingdom, the police have powers to impose on-the-spot fines for some kinds of violation. For example, there is now a very, very stiff fine for people who organize illegal gatherings of parties and raves, and fine of £10,000 to the organisers of such events seems to have had a little bit of, as you might expect, a little bit of an impact on the anxiety of people to organise such things. And the problem here is really enforcement. It's all very well to have these stiff fines and stiff and stringent rules, but if you've got enough police officers to enforce it, and frankly, we haven't. And we have rather allowed police numbers to slip on economic grounds over the last few years, and a lot of police forces are having to be very selective in their enforcement processes, and the economic resourcing of legal processes is a key factor, and one that we mustn't forget. Vaccines are regarded as the medium-term solution to the COVID crisis, and the eventual savior of us all. But should vaccines be made compulsory? Some people for very sensible reasons, but a lot of people for rather crazy reasons, seem to regard vaccines as some sort of nationalistic conspiracy to subdue us into goodness knows what. And the question might then arise of whether you actually make people in the wider public interest have these vaccinations, and if so, how do you make them do it? Very tricky one, that. Laws have economic impacts. They have impact particularly on employers and on landlords of rented property. And employers have had to learn all sorts of new things when people are laid off from work, when businesses have to shut down because people can't come into work and there are no customers. What are people's employment rights? And some emergency regulations may be brought in to kind of effect an orderly transition into this new world. But it's a difficult learning curve, and it's a difficult learning curve for landlords who are faced with new temporary tenants' rights to protect them from eviction during this very, very difficult period. And there are controversies with a strong legal flavour to them about procurement rules and regulations, medical equipment, personal protective equipment, medication, vaccines. These all raise issues to do with competitive tendering and intellectual property. Who holds the patents in medication and vaccines, for example? And further down the line, we may well see litigation arising out of this new world. Challenges for the courts presented by the COVID-19 crisis. And some of those consequences, many of those consequences, are economic in origin. COVID-19 has involved huge outlays of public expenditure, public health services, contact tracing, law enforcement, paying the salaries of police officers and support staff, job support schemes for those who are laid off during the during lockdown periods. These mean huge demands upon the public purse, and cuts have to be found elsewhere. And as soon as you start talking about cuts, I'm afraid the justice system is all too often seen as some kind of soft target. And in the UK, the courts have already been grumbling for a long time about economic austerity and budget cuts, and COVID have exacerbated and accelerated some of the consequences of this: court closures, staff redundancies, and so on. And an outcome of these kinds of things, particularly court closures, is much longer waiting times, parties to legal proceedings having to travel further, and of course travel restrictions, which are part of the COVID recipe for ameliorating the problem, may exacerbate this. Some defendants charged with serious criminal offences find themselves being remanded in custody for much longer, awaiting trial. Some judges have taken the view that if somebody's awaiting trial and they're going to be in prison for a long time and maybe acquitted at the end of the day, how on earth can you justify keeping them in prison? And so they've been giving bail to people who perhaps formerly they might not have been willing to give bail to. Social distancing. This, combined with the number of court buildings that have been closed down, is a very serious problem. In criminal trials, for example, which the more serious cases are tried by jury, you have a situation in which the people involved, the parties and their advocates, and the judge appear in court. The jury watches the proceedings on a screen in another room, sitting 2 meters apart, one hopes. And the public and the press, and we're talking about open trials, sit in another room watching the proceedings on television screens. And the prisoner at the bar may not even be in court. Increasingly, offenders watch the proceedings and participate as they're requested and required to do through audio-visual linkage. So, the impact on the nature of a trial proceedings and what it actually means, and what a fair trial actually means. Some questions have been raised by these recent developments. Now, the last point on the slide is that is a sort of plus point, but I put a question mark by it because some of the pluses may not be quite so plus as at first sight they appear. We have moved into the 21st century at last by introducing technological innovations, online hearings, electronic transmission and processing of documents, and that kind of thing. All one might think a big plus, but of course it's not quite such a big plus when you start looking at some of the details and at, for example, the digital divide, as it's sometimes called. Once you start moving into a world where technology is king, then it is poorer people, people who are less technologically skilled, less well educated, and have less access to computers and less capacity to make good use of computers and keyboards and so on. These are the ones whose access is most adversely affected, whereas the relatively wealthy and well-educated who have computers, are used to using them, are much more at home with this. So if you're talking about equality of access, then I'm afraid the movement towards high technology is a mixed blessing, as so many things are. So where are we going? Well, the traditional landscape of law and justice has, as I've said before, been under pressure for change in this country and in many other countries too for a very long time. And the COVID crisis has greatly accelerated and accentuated that pressure and accelerated that movement towards radical change. Judges and lawyers now have to accustom themselves to operating in a world of sophisticated IT and artificial intelligence, and a world in which information is routinely disseminated and shared on the social media. You'll probably be familiar with the phrase "the court of public opinion," which was always used in a slightly sort of light-hearted way, but actually increasingly, even before trials begin, particularly high-profile trials that attract a lot of attention, people are beginning to exchange views online about the rights and wrongs of the trial. And sometimes people find themselves accidentally or on purpose condemned by public opinion on social media long before the rather tardy and perhaps even increasingly tardy court process gets around to giving them a proper and fair trial. The third bullet point makes the point, which I think is quite important, that events like crises like COVID prompt the promulgation of emergency regulations, which are presented as temporary. Well, yes and no. Sometimes temporary things turn out to be irreversible. There's a sort of ratchet effect. Things move forward, and once having moved forward or sideways or even backwards, it's very difficult to restore them to their original position. And then, and this goes back to the Secretary General Guerre's remarks that I cited earlier, populism, social media, promising instant solutions to difficult problems may actually give opportunities to populist and nationalistic politicians who are impatient with some aspects of the rule of law, the excuse and the opportunity to sidestep it and to belittle it. There are traces of this, I'm afraid, in the UK, and there are traces of it in some other countries too. And the future of the rule of law, as lauded so strongly by Margaret Thatcher at the end of the 20th century, cannot and should not be taken for granted. On that slightly unhappy note, let me just make one last and slightly more positive statement. And this is from one of the most distinguished UK judges of the modern era, respected, I think, in many other countries too. This is Lord Bingham, sadly died a few years ago, who was president of the UK Supreme Court for several years. And any of you who want to read up on the rule of law, he delivered a series of lectures which became a book called The Rule of Law, which was published in the year 2011. And it's a brilliant overview of the subject. And he sums it up, I think, rather well. There are countries in the world where all judicial decisions found favour with the powers that be, but they're probably not places where any of us would wish to live. So long live the rule of law. Thank you very much for your attention. I think we're going over now to questions and the poll. Amanda, do you want to say something about the poll, first of all?
Yes, I will. I can actually launch the poll questions now, and we can see the answers. And also, just to let you know, we do have a few questions that have come in. So if I go to the first poll question, and I will just show the results to everyone.
Right, well, it's good to see that some countries have examples of this kind of legal proceeding. But can you hear me?
We can hear you loud and clear, Gavin.
Okay. Yes, it's good to see that more than a third of the participants have answered yes. So good to know that the rule of law in terms of holding big people to account in the courts is observed around the world. But the answer is no in some countries, and that may not mean anything at all, but it's good to know that some people, the answer is yes.
Okay, and the second poll question results.
Well, the winner in this poll is no change, which accounts for about half the responses, and about an equal number say that it's become easier to bring cases in the civil courts, and an equal number say that it's harder. So I think the answer here is it's a draw. In some cases, it's become harder. In some cases, it's easier. In some cases, there's no discernible change. So I'm afraid we will have to live with a neutral result on that one.
Okay, and the last poll question results.
Oh yes, quite heartening to see that judges are held in a good regard in as regards being uncorrupt in 2/3 of the respondent countries, but a little bit disquieting that a third of them are not. One hopes that judges around the world, you know, the first qualification for becoming a judge, apart from being a darn good lawyer, is that you should have the reputation for having clean hands. And the fact that a third of respondents don't think that their judges have clean hands, I find a bit disturbing. But it's good to know that a lot do have clean hands, so hooray for that.
Okay, we do have a question. Gavin, this is from Constance. Have there been any court proceedings challenging the constitutional right to a fair trial in situations where the jury and the defendant or other players in a jury trial have been placed in separate spaces due to COVID-19?
The answer is that in the UK there have as yet been no such cases. I think the legal professions have called a kind of truce on challenging this, because they know that if they don't proceed along these lines, then the backlog of trials, which is now, and I should perhaps have mentioned this, very considerable in the UK, this would really have slowed things down to almost zero progress. So some pragmatic compromises, I think, are tacitly accepted by all the actors in the legal system, or pretty well all of them. Though no doubt, if there were, if the, for example, I'm hypothesizing, if the internal cameras and microphones in this divided courts format broke down so that the jurors were not hearing some key evidence, and then they reached their verdict subsequently, well, that might well be a cause for the declaration of a mistrial or a subsequent appeal.
Okay, thank you, Gavin. Second question, does judicial independence mean there must be an absolute ban on any kind of parliamentary scrutiny of judicial appointments and judicial conduct? And that's from Brenda.
That's a very good question. I think it depends on the nature of parliamentary scrutiny. The judicial system, the legal system, is extremely expensive as well as being extremely important. And the idea that you should just completely put a brick wall between any kind of external scrutiny and an independent judiciary, I think is unrealistic. In the UK, a sort of compromise has been reached whereby the top judges, in particular the Lord Chief Justice, regularly appears before a parliamentary committee and gives a fairly candid and sometimes slightly controversial account of how the courts are being administered. But once you go into those kinds of scenarios, you've got to set pretty strict ground rules. And the basic ground rule is that judges must not be drawn into any kind of political controversy and must not be seen to be prejudging issues which might eventually come before them in a judicial capacity. But you have got to have some sort of parliamentary oversight, I think, of the administration of justice in a bureaucratic sense, as long as you steer clear of the substantive legal process that goes on in the courts.
Okay, thank you, Gavin. And that was the last of our questions. We do have some upcoming events as well, so please do check those out. What I'm going to do now is actually pass the controls over to you, Claire.
Well, hello again. This is Claire back again, Claire Cameron. Gavin, thank you very much for that very comprehensive and bang up-to-date analysis and considerations of the rule of law, COVID, Brexit, and so on. Thank you, everybody, for joining us. As you'll see, we've put a note there of some of the webinars and remote workshops and indeed some face-to-face workshops, which we're very much hoping to run next year, all being well. Two of Gavin's, which are on justice, fairness, and the rule of law, and another one on called The Judge Over Your Shoulder, which looks at decision making and the law, are scheduled for I think April and June next year. So all being well, if travel and so on get easier, we will be up and running with our London-based workshops, which normally are a very nice blend of briefings, discussion sessions, and visits. Gavin mentioned visits to the Supreme Court. We try to visit working judges, court managers, and lawyers in the justice sector, and similarly ministries and policymakers and civil service managers for our range of other programs. So please do keep an eye on our website. We will be in touch with you and let you know about our 2021 schedule. And in the meantime, we'll let you know if we're doing more webinars and let you know about some of the remote virtual workshops that we've got currently being planned. So just remains really for me to thank you so much again for joining us. I hope you've enjoyed it. Thank you for taking part in the polls and for the questions. And thank you again, Gavin, for steering us through for the webinar today.
My pleasure.
Thank you. And thank you as well, final thank you probably, to my colleague Amanda, who's been managing the whole process very smoothly, I think. I hope you've all found it a good experience, and I have certainly enjoyed it very much. So keep well, and we'll say goodbye for now. Thank you. Bye.
Goodbye, everyone.